In this lecture, we're going to talk about the United Nations Declaration on the Rights of Indigenous Peoples, by far the most comprehensive international global instrument relating to Indigenous rights in world history. It's enormously important both in capturing the global sense at the time of the rights of Indigenous peoples, and also as an advocacy tool for the peoples themselves and persons advocating for greater respect for Indigenous rights. We know a little bit about the history of the UN Declaration, which I also and others will also call the UN DRIP, or the DRIP, or the UNDRIP. Not the most fortunate of acronyms, but it's what we've got. As we discussed in a previous lecture, the document was the brainchild of the Working Group on Indigenous Populations, which had been established within the Subcommission on the Prevention of Discrimination and Protection of Minorities. In 1985, the Working Group proposed to the Subcommission that it draft a Declaration on the Rights of Indigenous Peoples for adoption by the General Assembly, and the Subcommission approved the plan. The Working Group, which consisted of 5 experts, then got to work with lots of input from Indigenous organizations, Indigenous rights organizations. They released their first draft in 1988, which was then discussed within the Working Group until 1993, when a final draft was released for Subcommission approval. The Subcommission approved the draft the following year in 1994 and submitted a draft to the UN Commission on Human Rights, which established its own working group of state delegations, which ultimately produced the UN DRIP. This working group, the Working Group on the Declaration of the Rights of Indigenous Peoples, met between 1994 and 2006. It was supposed to go a couple of years shorter than that, but got a pair of extensions in the hopes of achieving consensus on the document, which had been the original goal. That never happened for reasons that we'll discuss. But there was enough consensus by the end of the 2006 session that the chair of the working group was prepared to call the proceedings closed and submit the document then to the Human Rights Council, which had replaced the Commission on Human Rights. The process of negotiation was historic and extraordinary, and I want to share some of my experience with that process momentarily. I, as I mentioned in an earlier lecture, was private sector advisor to the US delegation, which is to say I was their designated expert on US Indian law and potential implications of adoption of the UN DRIP for the final 3 years of the negotiation between 2004 and 2006. The historic component of the negotiation, I want to say first, was the active involvement of Indigenous representatives. Ordinarily, in the negotiation of international instruments, the only people in the room are representatives of the state members of the UN who were involved in the drafting of whatever the instrument happens to be. So you'd have delegations from all of the states, all the countries, but the people impacted by the substance of the negotiation aren't in the room. They're allowed to express their opinions in other ways by submitting written suggestions and questions and comments and that sort of thing, but they're not actually in the room when the negotiation's taking place. That would have been true for the CEDAW, or for the ICERD, or for international instruments dealing with the rights of disabled people. None of these had active participation in the room, in the negotiation room from the affected groups. But the UN DRIP was different, and that was because of the persistence of advocates for Indigenous peoples. And in fact, at certain times in the room, when I was there, it felt like the majority of people were Indigenous representatives, and certainly for long stretches, the majority of people taking the mic and expressing their views about the articles under consideration were Indigenous peoples' representatives. This was true in both plenary sessions, which were sessions in which all of the members participated in discussion, and in breakout sessions, which were dedicated to consideration of individual articles or parts of articles where people who had a particular interest in the topic would go to offer their opinions, their suggestions, and their advice. The way that these things were structured, these meetings were structured, was to break the entire document, which is fairly long. It's 46 articles and 23 preambular paragraphs, as we'll get to in a minute, but to divide it up into manageable segments where the group might discuss 3, 4, 5 articles at one session, and then at the next session we would discuss a different group of articles. It wasn't done sequentially. It was done more thematically, and because the document moves around a bit, as we'll discuss, this meant we'd be pulling articles from the end of the document, talking about them with articles from the front of the document. Sessions were 3 weeks long. Everyone would arrive at the Palace of Nations in Geneva in one of the large assembly rooms and greet each other. The way the UN works is that seating for the states is done alphabetically. But from session to session, the language used for the names of the country switches from English to French. And what that means is that for the first round, the United States might have been seated next to the United Kingdom. But at the next round, at the following round, we would have become les États-Unis in French, and we're seated next to Estonia, which is, of course, alphabetical in French. And that movement around, this didn't affect every country, but certainly affected the US, gave us the opportunity to get to know a bunch of neighboring delegations fairly well. The articles to be discussed would be announced at the end of a session to give folks time to prepare their thoughts, their responses, et cetera. In the US, that involved the State Department, which took the lead on the negotiations, contacting potentially affected US agencies, the Interior Department, certainly, the Environmental Protection Agency for environmental provisions, the Defense Department when trans-border issues were under discussion, the Department of Justice, which was an active participant and interested in all of these articles. And each of those agencies would have the opportunity to comment in multiple sessions with the lawyers from the State Department, who again took charge of the process and chaired the delegation. And some of them would send representatives to be delegation members. The US delegation during the years that I participated as private sector advisor was usually from 5 to 7 members. There was always somebody there from the Justice Department. There was usually somebody there from the Environmental Protection Agency. And there were always several people there from the US Department of State. And then I was there as private sector advisor, which was to say that my role was to be independent. I don't work for the US government, but to answer questions as they arose as to potential implications if the US were to agree to various provisions. And I want to say something about that because it says something about the posture of some of the states involved in the negotiation, not all of them. Technically, the UN DRIP is an aspirational document because it's a declaration, and that's what declarations are. And I credit this to the working group and the Indigenous advocates who were there, the Indigenous caucus as it was called. Some of the language in this, a lot of the language in this, is so precise that it doesn't read like an ordinary declaration. Which is usually filled with sort of grand, ambitious goals. This is very precise. States shall language, create mechanisms to, et cetera. And those don't sound aspirational. Those sound like the provisions one would find in a convention or treaty. And so a lot of folks since then have made that argument that this ought to be construed as a convention, even though technically it's a declaration, or ought to be construed as evidence of customary international law because of the obligatory nature of some of the terms. And that's something we'll talk about at the end of the lectures on the UN DRIP. But back to the attitude of participants, a number of states came in viewing this as merely aspirational, which is to say it didn't really matter what it said. We're under no obligation to do any of this. And so those states, I think, evidenced less interest in thinking through potential domestic implications of adoption of particular language. The US, Canada, and a number of other states came in with a different mindset, which was, we don't want to agree to something we wouldn't be prepared to do. And I think that affected the interplay. It also, by the way, as we'll discuss in a minute, impacted the final vote on this. Some of you already know, I'm sure that when the document came to the General Assembly, the final vote, great majority in favor, but 4 states voted against: Australia, Canada, New Zealand, and the United States. And then there were a number of abstentions. But those no votes were all states that had evidenced concern with their ability actually to enforce the provisions of the UN DRIP, despite the fact that it's technically an aspirational document. And that explains in part why they voted no, and other states which have less robust Indigenous peoples law systems domestically voted yes, because they didn't really plan on attempting to implement implement any of this. Now, the negotiation was divided into 2 sort of large parts. There would be plenary sessions. The rounds always began with a plenary session where we would all sit down in our seats. Indigenous peoples, the Indigenous caucus would meet independently, and then they would take their places in the room, and we'd begin discussion at the opening of a session by offering up thoughts of states on the articles that we knew were being considered. And so the US might take the microphone and say, well, you know, we've been through this one's fine, this one's almost fine, but we'd like to make this amendment to it, and here's why. This one we can't do, but here's an alternative that we think would accomplish the same thing, and this is why we think that's good. And then other states would express their opinions on the articles to be considered as well, and then there might be a general discussion, and then there might be a breakout sessions, where the people interested in talking about the treaty article would go to one room, and folks interested in talking about the intellectual property article might go to another room. And those would be smaller negotiations about what the language should say, what it could say, how it might be interpreted, etc. Then the breakouts would come back together into plenary, and eventually the goal was at the end of each session each 3-week session to come to some broad consensus on the language of the articles under consideration, and then we'd see what the articles to be talked about the next time were, they'd be posted, and everybody would go home. That's part of the story, it turned out. That's how it was structurally organized. But what I learned there as private sector advisor to the US is that while some discussion and negotiation certainly goes on in the room during the course of the business day, a lot of negotiation takes place after hours. And so people would leave, they'd go back to their hotels, they'd change clothes, and then they'd get together with folks they wanted to visit with. The Indigenous caucus reps would meet with each other, sometimes with the states. The states around the room would meet with each other. Canada might have dinner with Bolivia. Argentina might talk to Guatemala and some other Latin groups, or maybe some Asian states. I had an interesting session talking with the Japanese delegation about how US courts, tribal courts worked, because they were interested in the provision relating to tribal judicial systems. They couldn't see how it operated in Japan, and they wanted a sense of how that sort of thing operated elsewhere. And those conversations went on after hours. I was much younger then, so could do this. And something happens when you're in Geneva, I guess. But they would routinely not finish until 2, 3, 4 o'clock in the morning, those after-hour sessions. And then you'd go back to your room, sleep for a couple hours, and then you're back at the Palace of Nations by 9 a.m. to start the next day's session. And after 3 weeks of that, you're kind of tired, but you've gotten a lot accomplished because they're almost 24-hour work days, formal and then informal negotiations, trying to push through language that will work given the broader objects of the negotiation. So in 2006, the negotiations finished. The document produced by the working group was, as you'll know from reading it, incredibly comprehensive, covering a huge variety of subject areas. Most of the areas that we talk about in a comprehensive federal Indian law class were discussed in the Declaration, although it's a bit more general in nature than an Indian law class would be, because it's a document that's meant to cover the situations of Indigenous peoples, not just in the United States, which is a common law country, or Australia, which is a common law country, but throughout the world in a variety of different legal regimes. The document contains 23 preambular paragraphs and 46 articles, which are the operational provisions. So the preambular paragraphs say, whereas this, whereas that, and then we get to Article 1, okay, so this is what we're going to do about it. And that's what Articles 1 through 46 deal with. They're operational, they're structural. They set out the rights and the remedies. The original goal was consensus, as I mentioned, but that never happened despite a couple extensions. Nevertheless, in 2006, the working group declared its work complete, and the draft was submitted to the UN Human Rights Council, which, as I've mentioned now several times, had that year replaced the UN Commission on Human Rights. The Human Rights Council approved it on June 29, 2006, fairly expeditiously, with 30 votes in favor, 2 votes against, 12 abstentions, and 3 states that didn't participate. They weren't there. The DRIP was then referred to the General Assembly, which voted the following year, September 13, 2007, to adopt the UN Declaration of the Rights of Indigenous Peoples. That's the historic date for the UN DRIP, September 13, 2007. The vote was 143 states in favor, 4 against. As I mentioned, they were the US, Canada, Australia, and New Zealand. 11 abstentions, including the Russian Federation, for reasons that I'll talk about later, and 34 absentees, 34 states that didn't vote one way or another that weren't because they weren't present. Since that time, the 4 no votes have all become yes votes. The Australian government on April 3rd, 2009, changed its position. New Zealand on April 19th, 2010. Canada, November 12th, 2010. And the United States, the following month on December 16th, 2010, changed its position and said that the government would now adopt the UN Declaration, support the UN Declaration of the Rights of Indigenous Peoples, which means we have no votes now. So it becomes, this is a part of the argument that it ought to be considered customary international law. Now, let's look at the provisions of the agreement, and I'm not going to talk about all of them, but I'm going to focus on many of them. And my goal is to give you a sense of the sorts of things that are covered, the problems that came up in negotiating that might have led to the 4 states deciding initially to vote no, and how the document can be used by Indigenous advocates in a practical way. Article 1, and we're not going to deal with the preambular paragraphs. We're just going to go straight to the operational provisions. Article 1 recognizes that Indigenous peoples can exercise rights collectively as well as individually. That's huge and was one of the grand complications of the UN Declaration of the Rights of Indigenous Peoples. Let me explain why. from the origins of the modern human rights system, which, for argument's sake, let's trace to the 1944 Declaration, UN Declaration of Human Rights, but actually extends before that. When international players thought and talked about human rights, they were thinking and talking about individual rights. These are the rights, for instance, enshrined in most bills of rights, including the Bill of Rights to the US Constitution. Free exercise of religion, self-incrimination protection, right to bear arms. All of these are rights possessed by individuals and exercisable against their government. We don't really have an international instrument, with the possible exception of the ILO conventions, but certainly nothing within the UN system, that protects collective rights. And for a while there was a debate, and as there still is, over whether they're even technically human rights, since human rights is a term of art referring to individual rights. These are collective rights. They're rights exercisable against states, but exercisable by groups of people. And sometimes they may come into conflict with individual rights, which is a potential problem under the UN DRIP, that the DRIP will resolve in favor of the individual, arguably, but that's still an area that generates some discussion. So Article 1 recognizes that there are certain rights that will follow that are to be exercised collectively and certain rights that are exercised individually by individual indigenous persons. And you'll see the language in the following articles reflect that. When it says indigenous peoples have the right to, those are collective rights. When it says indigenous individuals have the right to, those are the individual human rights. And again, this is the first comprehensive indigenous rights document that to a great extent attempts comprehensively to assign to both the collective and individual indigenous persons a huge number of rights. So that's Article 1. Article 3 is the self-determination provision. It says, and I'll read it, indigenous peoples have the right to self-determination. So we know that's a collective right. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. All right, this self-determination language is lifted from Article 1 of the ICCPR. And its inclusion in the UN DRIP was controversial. The reason is that the ICCPR language, self-determination language, has been construed to, for one thing, recognize statehood in peoples, which would elevate the status of indigenous peoples within the international system, but also to allow for a right of secession. So if you are a people with a self-determination right under the ICCPR, then under some international law, decisions you can secede from the country or the state in which you find yourself and form your own state. And there was great anxiety expressed by a number of states that shouldn't be the way this was left in the UN DRIP. And I'll tell you, it wasn't so much, and this is my sense, because the states were concerned that the Chickasaw Nation would secede from the United States. It was for different reason. And I'm going to foreshadow something that I'll talk about a little bit later, and something you may have noticed. Ordinarily, conventions, as those we've discussed, begin with definitional sections. The ICERD begins by defining racial discrimination. There is no definitional section in the UN DRIP. It's the Declaration of the Rights of Indigenous Peoples. Nowhere does it tell us who indigenous peoples are, what defines an indigenous people. Which is to say, at the end of the day, we're left not knowing entirely to whom, to which groups this instrument actually applies. Now, we might say in the US, oh, well, it's obvious. It's the tribes. Or maybe it's federally recognized tribes. And it probably is, and everyone in the US assumes that's true, and the tribes assume that's true, and we don't really have a whole lot of discussion about this in the US. They don't in Canada so much, although they might have. The Métis, who have now been recognized as Indian peoples, weren't at the time of adoption, and there might have been some question whether they qualified for whatever rights are protected under this. But if you move farther afield in the world, it becomes even more complicated. The Russian Federation expressed concern that the Chechens might be considered an indigenous people for purposes of the UN Declaration of the Rights of Indigenous Peoples. What that might have meant is if the Russian Federation had voted in favor of the document, the Chechens might have said, oh, well, that's a vote in support of our right to self-determination as an indigenous people, and we're going to declare independence. The same problem confronted the US and other states in the Middle East with the Kurds, who might well have said, well, we're an indigenous people. The US and other states have just voted to adopt this decision. That means that they recognize our right to declare independence as an aspect of our self-determination right as a people under Article 1, and that language is taken from the ICCPR, and that includes a right to secede. Same with the Palestinians, who might declare, oh, we're an indigenous people. And there's nothing in the document that says that's wrong, again, because there's no definition. That's one of the weaknesses of the UN DRIP. It may also be one of its strengths. The lack of a definition, I think, is part of what made it possible for the document actually to appear. If there had been a fight over who's an indigenous people and who's not, I suspect we'd still be there negotiating that. But again, it's left a hole that's created for some political complication. The secession problem was dealt with by the inclusion of 2 additional articles, which are there ostensibly to qualify the Article 1 self-determination right. One of these is Article 4, which says, indigenous peoples in exercising their right to self-determination have the right to autonomy or self-government in matters relating to their internal and local affairs, as well as ways and means for financing their autonomous functions, which is to say, self-determination means you can govern yourself, but you're not supposed to have any relations with other outside political communities. That would be an attribute of statehood. That wasn't enough when this reached the General Assembly for some states, including many members of the African bloc, who had the same concern about tribal groups declaring themselves independent within African states. So Article 46 was added to the document, and that provides nothing, and I'm going to read the relevant portions of it, nothing in this declaration may be construed as authorizing any action which could dismember the territorial integrity of states. That's an express statement that secession is not included among the rights protected in Article 1. We'll stop there, and when we resume, we'll pick up with Article 5.